Good morning. It's Friday, March 17th, 2023. This is the third installment of Senate Natural Resources Amendment this morning. We are turning now to Bill S80 and activating miscellaneous environmental conservation subjects. We have reviewed that bill as a committee with the Agency of Natural Resources, and now we have our own counsel in the room, and Mr. O'Grady, if you could just join us at the table. Do you have copies? Or oh, here we go. Chief has copies. Thank you so much. So we're looking at draft 1.3 of S80. I think, unless committee members want to review another section of the bill, we just have a very brief visit because we have only a short addition to the bill since we last reviewed it in its entirety. So good morning.
Good morning.
If you could just point out what changed since our last draft.
On page 3 in section 4, in the section that allows a salvage yard that does not hold the proper certificate to use a mobile crusher to shut down, you'll see on page 3, line 6, it's clarified that the mobile salvage vehicle crusher has to have a liquids collection system.
Okay. And as a curiosity thing, it's also in accordance with rules adopted under the subchapter. Do those rules not specify such a provision? Is this a belt and suspenders provision? Do you know? We're making a switch to something that was already inherent in the rules.
I don't know. I read the rules like 3 weeks ago, but I don't remember if.
Ms. Smith, can you chip in, maybe?
This is Hannah Smith from the Agency of Natural Resources. The rules don't specify the modifications required on the mobile crusher itself. It does require inspection for any spills. So it implicitly requires that there be a prevention of any liquid leakage. So the agency feels that this is a belt and suspenders provision because you're not allowed to spill liquids on site under the salvage yard rules, but also is not opposed to this addition as an extra precautionary measure.
So the rule says you can't spill, and this says here's the way to avoid spilling. Okay, with a liquid collection system. Okay, so that's pretty straightforward. Thank you both. Any committee questions for Mr. O'Grady? Okay, thank you. Any committee questions for Ms. Smith? All right. Thank you, everyone, for getting us the finely tuned draft 1.3. With that, if there's no further discussion, I'd like to welcome a motion to amend S80 as outlined in draft 1.3.
So moved.
Moved by
Thank you, Senator McCormick. Any further discussion? All right. Clerk shall call. Do you want to step in the hall and see if?
I can be very slow. Senator.
I need to see if she's there.
Thank you, Mr. O'Grady.
Okay, Senator McDonald said yes. Senator McCormick.
Yes.
Senator Watson.
Yes.
Perfect timing. Senator White, yes. Senator Bray.
Yes, thank you. very much.
5-0.
Would anyone like to report this bill? Happy to do it, but I don't want to cut anyone off.
Well, I was really looking forward to it, but I'll defer to you.
It's kindness.
Yeah.
So I'd be happy to report.
It is likely going to go to appropriations
Right.
because of the PCF fund, at least. This are changing amounts.
Okay, thank you for that. Right, and Ms. Smith, I'd like to half of you over, I mean, there are quite a few dollar figure changes to that section, so maybe I could sit down with you, or you could help outline the rationale for all those smaller edits.
Yes.
If you see that. Okay,
Absolutely.
great. All right. Good to see you, Mr. O'Leary.
Are you gonna hear from the Attorney General this morning?
Yes, although they're not scheduled to be until, well, 10:45, they should be here at any moment.
Justin,
I just think there's a couple of tweaks to their language that need to be made.
Okay, so well, let's jump to it then, and we can get a head start. The bill that we're talking about is S-33, an act relating to miscellaneous judiciary procedures. The bill is in judiciary.
yeah, they sent it,
This
this
is
is the
our
latest version.
Flyover.
This is
Yeah.
a review.
So we don't vote on this. We just kind of.
This is, we could straw poll ourselves, but I don't think we need to do that. It was really
Oops.
as a courtesy that Senator
There they
Sears
are.
suggested that we might want to look at it and better understand, since this committee is intimately involved in issues related to contamination, particularly in the last 6, 7, 8 years, PFAS, and especially like the vent. But judiciary is the one handling it. So, Mr. O'Grady, if you could bring us to the section of this bill that we should be reviewing, and then give us a backgrounder so we understand it better, that would be helpful.
There's no section in, well, actually, I don't know. Has it been added?
This is 3.1 that was just sent to me.
I was not the drafter, so this was Eric.
Yeah.
Eric's unavailable.
Thank you for pinch hitting. I heard it as an issue as opposed to, I did inquire about, is there a section number? And
It's on page 22, section 26. Draft 3.1. So generally for civil action courts in the state, there's a 6-year statute of limitations in which a cause of action can accrue. There was a recent,
Pardon me, sorry. This is draft 2.1 of S-33, and we're on draft 3.1.
So we have an old version. This is for fun.
Already
Just that's.
superseded. So
So I don't do anything with,
No,
the
give it back to
2.1.
me.
So let me, just to make sure if anyone's following, they're looking at our website, they're listening to this conversation. We're on draft number 3.1 of S-33. It's timestamp 3/17/2023, 9:56 a.m. Okay, so thanks again. Back to you.
so generally underneath Title 12, Section 511, there's a 6 years statute of limitation in which civil tort action can be brought for whatever the damages or the consequence of the action would be. There was a recent Vermont Supreme Court case that said for under the continuing tort doctrine, it's basically a doctrine that allows that 6 years statute of limitations to shift depending on if the violation, that the alleged action that caused the harm is quote unquote continuing. And the court said something a little unusual that will basically have significant implications for environmental contamination civil actions. The court said that in order for there to be a continuing tort doctrine case to shift that 6-year limit, you still need to have a tortious act within the period, the statute of limitations, and within that 6 years. And that's really difficult when you think about environmental contamination, because it's could be there for decades. And if that tortious act occurred years ago, the release then you don't have that ability to bring that cause of action. And so the Attorney General's here to present a proposed language. I'll let them do that. But I do have ultimately a couple of questions about the language and one specific recommended change.
Okay. Would you like to have them present first and then?
I think they should present
Yeah.
their language. It's their language.
So, yeah, so I want, while you're still there, can you explain again, if it's a continuing,
You probably want them
Okay.
to do that. They're the ones that actually bring the action.
okay, thank you, Mr. O'Grady. And with that, I'd like to turn to the Attorney General's office. I don't know if you would both like to speak with us. You can always pull up 2 chairs, or you just say,
the chair.
choose your own adventure in terms of who comes to the table.
I'll take the hot seat. Laura may or may not chime in.
Okay,
Good morning, everyone. For the committee, I'm Justin Colber. I'm an Assistant Attorney General, and I'm the Chief of the Attorney General's Environmental and Public Protection Division. And I'm here to talk about the proposed language that we've been discussing about the accrual date for environmental contamination claims. And I'll start with the statute of limitations that Eric has described. It's generally 6 years in Vermont when it comes to civil actions generally, and there's no distinction among plaintiffs, whether it's a state or a private litigant. And the 6-year statute of limitations is just a clock. So the question is, when does that clock start ticking? And it's based on an event or a circumstance. And that makes sense in the normal course of litigation and lawsuits. If I was in a car accident, that's the event that's going to trigger the 6-year clock. If it's medical malpractice, it could be the date of my surgery. When it comes to environmental contamination, as was already previewed, those cases play out very differently. The contamination can take years to be put into the environment. It can take years for it to build up to harmful concentrations. It can take years for it to be discovered. It can take years to continue to investigate and understand how harmful it is. And then it can take years to investigate. And so a 6-year clock on environmental contamination can be problematic. It has been problematic in the past. There was one instance where the state brought a case against gasoline manufacturers and companies that were using the additive known as MTBE. That was something that was used in the 90s to make engines more efficient. And in that case, we did get a negative ruling that said the state was limited to the 6-year window of when MTBE was in Vermont's natural resources. And so we think that's very challenging policy for cleaning up environmental contamination claims. So what we're proposing is to really clarify and clean up, excuse the language, when the triggering event is for your 6-year clock for environmental pollution cases. And we think the triggering event for when the 6 years starts is each day that the environmental contamination remains on the property or in the natural resource. The idea is, as long as that contamination is there and causing harm, causing an injury, you should have 6 years from that date to bring your claim. And that fits with what I'll now describe as the continuing tort doctrine. That's a common law doctrine that developed among legal cases all over the country, including in Vermont. And there's kind of a split in the country of which version to follow. There's 2 versions of the continuing tort doctrine. One version is the broader test, which is referred to as the injury test. And that one just says, as long as your injury is still occurring, and it's broader than environmental contamination, it could maybe fit into a medical malpractice claim. If there's an injury that's continuing to this day, you're still being harmed from that defendant's conduct, you can bring your claim even if it goes beyond the limitations period. We think that's a good test. That's the broader test. About 26 states in the country follow that, including some sister states of ours like Maine and New Hampshire, Washington, California, New Jersey, and many others. Then there's a second test known as the conduct test. That one's narrower. That's followed by the other half of the country. Around 24 states follow the conduct test. And that one says, as again was explained by Eric, if the injury is still occurring, you also need to prove that the defendant did something recent within the last 6 years. So the example could be, let's say we have a defendant who put environmental chemicals in the environment 10 years ago, and those chemicals are still there causing harm. Under the injury test, you could proceed under that. Under the conduct test, you would say, okay, but what did they do in the last 6 years? They put in the ground 10 years ago. Did they do something again in the last 6 years that was wrongful conduct? We think that's a narrower test. And we think it's been very unclear in Vermont how these tests have been adopted. And the most recent Supreme Court case from January of this year wasn't an environmental pollution case. It was a private landowner who sued the state because of stormwater runoff due to roadway construction. But in that case, the Supreme Court took it upon itself to analyze, well, is this a continuing tort? And if so, in Vermont, we think continuing tort means wrongful conduct in the last 6 years. The court didn't even end up applying it, but it provided that analysis, and we think made it even more unclear which version of the rule Vermont is following, and if it is following the conduct test. Again, we think that's not good policy, especially for environmental contamination claims.
So is your office then arguing for the broader test that you first outlined?
Yes, we think our proposal basically codifies the injury test, the idea that as long as the contamination, the harm continues to exist on the property or natural resource, then your claim continues to be valid. The 6-year clock, it will not expire if that contamination continues to be there.
All right,
Makes sense.
Sarah McCormick.
The injury test, what if the injury doesn't become apparent until many years later? I mean, I don't know how solid the science, but I know there are certain cancers that are at least thought to perhaps be the result of like a time bomb. And we're told if you gave up cigarettes 20 years ago, your previous cigarettes may yet cause you a lung cancer. That is a real hypothesis. I don't know if it's been nailed down yet.
Sure.
What about that? It's not in the environment anymore. Of course, the cigarettes is another issue anyway. I'm just using that as an example of the delayed effect.
Yeah, so I think if I understand the question, there is a principle in the cases that talk about when something should reasonably have been discovered. So if you wouldn't have had any basis to know that there was cancer growing in your cells until X period, you would still be okay to bring your claim. And so that idea of when something should reasonably have been discovered, that's built into the law. And our proposal, wouldn't affect that standard.
I'm just trying to, is there any window of escape here for the polluter?
There are no windows.
What's that?
It's open air.
Yeah. Well, we don't think so. We think this proposal would make it very clear that a polluter would still be on the hook if the harm and pollution they cause continues to remain on the property in the natural resource. That's what we want to do. We think that's good policy to be able to go after the polluters who cause harm, even if it's over 6 years.
Senator White?
Thank you, Senator Bray. So just a real world scenario that I'd like to play out. So I live in a low income neighborhood and we are next to a former dry cleaner, a really large chemical related use dry cleaner. And there is testing that is happening on the property. And there are properties around us that have pipes going out of their homes, out of their basement to vent out toxins. What are the implications of this change if there are any on the requirements for testing? Does it change the onus on who has to pay for the testing to find out that there's a problem? Yeah, I want to make sure that in the situation like what I'm experiencing, that the people who are low income or the people who are around potentially a problem aren't on the hook. This does not change any of that.
It does not and should not. This will not alter any of the existing requirements that are already on property owners or any person who's running or a business that could have contamination. There's already a host of environmental statutes and requirements for them to do cleanup and testing. Our Agency of Natural Resource works on contaminated sites and does that work.
Yeah.
What this does would really broaden the ability of neighbors to preserve their claims while the investigation, testing, and remediation is going on. And maybe that does take longer than 6 years. And that's another reason this could be good policy, is because the State Agency of Natural Resources wants to work with parties. They want to help clean that up. And under existing law, they might also then have to file a case to preserve their claim in a 6-year window. It could take more than 6 years to clean up the dry cleaner site.
It has, yeah.
Exactly. And so we don't want to have to derail that process just so someone can preserve a litigation claim. We want parties to work together and ultimately clean up the sites to the best of their ability. And then if things don't get cleaned up, things do go wrong, well, litigation might be the answer then. And in that case, we want the litigation to be available, whether it's to the state or the private party. And this proposal would make it clear that if the contamination is there and harming people and they didn't clean it up, you can still proceed with your claim.
Okay, thank you. That's very helpful.
Yeah.
Well, thank you. It sounds,
I'm happy to walk through any nuts and bolts of the language as well, or
sure, why don't we haven't done that, so maybe let's just walk through section 26, which is pretty short.
sure. And so what we're proposing is to add a new section to Title 10. That's the Conservation and Development, where environmental laws are. Chapter 211 is civil enforcement. So the previous section 8221 is about the civil enforcement regime for the Attorney General to represent the state. This would be a new 8222. We think that's where it makes sense to put this. And subsection A right there, that's the meat and potatoes of what this does.
I apologize, where are we?
Page 22.
Thank you. And so the very first subsection there, 2 sentences, that's the meat and potatoes. That's the heart of what this does. And it says that your claim of environmental contamination is common law or statutory. So common law being nuisance, trespass, negligence, statutory being anything that's based in a statute. Title 10 has a host of statutes. The cleanup regime I was just talking to with Senator White about, that would be a statutory claim. All of those would apply here. And it says your claim will accrue each day, so long as the contamination remains on or in the affected property or natural resource. And that phrase, so long as, that comes from case law as well. That was a change that was recommended yesterday by Senator Baruth. And the accrue is really the timing. It's when does your event or circumstance trigger the 6-year statute of limitations. So again, we're not changing the statute of limitations. There's still a 6-year clock, but your clock doesn't start ticking until the contamination is accruing each day. Meaning if the contamination stops accruing each day, it's cleaned up, the dry cleaner cleaned it up. Now you do have a 6-year clock to bring your case. But if the contamination is still there, well, it's 6 years from today. If it's there tomorrow, 6 years from tomorrow. It's a perpetual 6-year clock each day the contamination is there until it's cleaned up.
Okay, now this gets back, Matt,
Yes, please.
this gets back to my question.
Yeah.
The contamination is cleaned up. And 8 years later, someone gets sick from what may have been exposure. They want to bring that case. They can't, right? Because the 6 years from the cleanup has expired.
You know, I think they might still have a claim of their own medical injury and negligence. So their claim wouldn't be the actual damage from the environmental contamination. It wouldn't be the soil and the water that you hurt. It would be my body that you hurt, because they couldn't reasonably have discovered that until 8 years later.
So they got sick.
Exactly. Yeah. So you still have your own personal claim for your medical injury, but you wouldn't have your environmental contamination claim for damaging your groundwater if you got it from the groundwater.
So we're not imposing blame, but we're imposing responsibility.
I would say we're making clear that the timing for when you can go after responsibility is always available for a plaintiff, whether it's a state or a private person. And the reason we didn't distinguish between private litigants and the state is because our current statute of limitations regime already makes no distinction among plaintiffs.
Okay. Thank you. And just so we do go through it, if we could walk through the rest of the section, that'd be great.
Sure. So then the next subsection B are the definitions. Environmental contamination we refer to as any hazardous material or hazardous waste, which is already predefined in law. And then we have a catch-all of any other substance or material that has the potential to adversely affect human health or the environment. That language also comes from other environmental law. A&R has a cleanup rule that has that language. We've also included property to include buildings or other structures. So your property is not just your yard and your groundwater. It could be your house, your building, your structure. And we define natural resource to have the same meaning that is defined in our existing environmental statutes as well. Very broad: soil, groundwater, biota, biota, air, aquatic life, et cetera. Natural resources are already defined and it's very broad. And then subsection C there is just a catch-all, belt and suspenders to make sure that we're not otherwise limiting any other later date that may apply. Again, the idea is parties should have the benefit of the latest accrual date. We don't think there's anything else that would be later than this, but we're just making clear that we're not going to shorten something inadvertently by this statute.
Okay.
Our next section is an effective date section with a slight retroactivity. So it says claims will be valid once this law is passed, but also anything that's pending as of the effective date. So it's slight retroactivity to a current matter that's pending. And we make clear that we're not going to undo any final cases that have already been brought that may have been able to be brought under this new rule. If it was a final judgment, those aren't going to be reopened. That's about separation of powers, making sure we're not undoing a court final judgment. And this language also tracks with other statutory language that makes things effective as of, pending cases. There's a Second Circuit case that uses this language, so we thought that was okay to do here.
Okay, can you remind the committee of the provision that we're notwithstanding there in 1 VSA 2014? What that provision provides for and why we're notwithstanding it? Surveys.
That's the retroactivity, right? So there's normally a presumption against retroactivity unless the legislature is very clear that you're making it retroactive to some period. And so here we are making that explicit. We're saying we're going to be very clear that it's going to be retroactive to anything pending filed. If there's a lawsuit that's already filed and pending, once this law goes into effect, they get that benefit of retroactivity. And that's also valid in Constitution when legislatures are explicit to say when they want the law to reach back to something.
Okay, great, thank you. Anything, Mr. O'Grady?
I think you also need to notwithstand 213, because 213 is the provision that says pending suits are unaffected by prospective law.
Yes.
And I also wonder if you're notwithstanding clause
Thank you.
Go ahead, Mike.
is too broad, because you notwithstand any other provision of law. Then be notwithstanding 815.
Good catch.
I'm sorry, the second one I didn't quite catch. Can you say?
So
that again, Mr. O'Grady?
on page 22, it says notwithstanding 1 VSA 214 or any other provision of law. Well, any other provision of law would include the next section down, section 27. So you're notwithstanding that statute of limitations under 6 years from the date of accrual.
I think it's okay because.
I was just going to jump into that one.
Yeah.
Yeah. So maybe I should mention that I didn't walk through the very next section. So 80, what Eric was referring to is in 10 VSA 8015. That's another 6-year statute of limitation provision for environmental cases. And it says notwithstanding any other provision of law, your environmental case brought under Chapter 211 is 6 years from the date the violation was discovered, or when the continued violation ceases, or we're adding this new language that's underlined 6 years from the date of accrual under our new section. So we're clarifying that an environmental case brought under Chapter 211 now gets the benefit of this new provision.
Okay.
Yeah.
And how about the section 213 proposed addition? Is that appropriate to you?
I think that makes sense to now say notwithstanding 1 VSA sections 213-214 or any other law. Eric, would that work for you?
I would like to say any other
Mark.
provision of law to the contrary.
Great.
I think you can leave any other provision of law in 815.
Yep.
So, always helpful to have a second set of eyes. Anything more, Mr. O'Grady? Or
No, and I apologize for bringing this up now. I would have done this before now, but I didn't have time. I'm sorry.
That was on us for bringing this at the time we did. We really are appreciative of you guys taking this up with us. So thank you.
In terms of, because we don't have possession of the bill, I think the most direct thing to do is to have judiciary amend their own work
Oh,
to bring this
that's a good point.
provision in, rather than us bringing a provision to amend the bill they're moving. So if you could double back to judiciary and let us know if they're both agreeable to the change and finding a way to make that change. Otherwise, and I'll check in just on behalf of this committee with Senator Sears to make sure that the baton pass is made clean.
And I'm happy to straw vote that, yes, I support us making this correction in our pass through.
Yeah, so that would be helpful. So, sometimes when we're speaking about a provision in another bill, we'll just stand and represent the committee's position. So with that in mind, let's do that. All those in favor of supporting this proposed new language from the Attorney General's office to be added in S33 as further modified today, in here, please say aye. Aye. Senator McDonald, are you an aye?
Yes.
Okay, all right, so 500 on committee support. Thank you, everyone, for helping us stay up to date. It's something of great interest to the committee that's not actually happening in this committee. And with that, we're complete our work. Thank you, Mr. Colbert. Thank you.
I'm gonna open the door.
I'm sorry.
I was doing a public school evaluation
So,
in our, up in the northeast